Welcome to Trust and Estates. This semester, we'll be talking about wills, trusts, estate administration. Chapter 1 is designed to give a very broad overview dealing with the gratuitous transfer of wealth. Gratuitous meaning there's nothing coming back, no consideration, no bargain for exchange. It's going one way from the testator or settlor or decedent to the respective beneficiary. The book is broken down into two main parts. We'll be focusing on part 1 of the book, which covers chapters 1 through 9. There will be forms available that are laid out in the appendix, also available on Canvas. Trust and estates law is a function of state law, and we will be looking at Maryland. But in addition to Maryland, we will use the Uniform Probate Code, which is a model, as comparison. Although the UPC is tested to the extent that you understand the issues and answer it using rules from Maryland, you would be absolutely correct. The one big thing that we need to think about is if I look at a list of assets, every single asset can be categorized between probate and non-probate. So I want you to think about that from the beginning. What is a probate asset? A probate asset is an asset in someone's sole name. What is a non-probate asset? A non-probate asset is everything else. Why? Because some transfer inter vivos, meaning during lifetime, occurred that allowed that property to pass differently than through the will or intestacy. An estates and trust practice includes an estate planner who does a lot of drafting, an estate administrator who might deal with estate administering estates from the death to how those assets get into the hands of the new beneficiaries. Estate litigation, there's some overlap, but typically estate litigators are not planners and administrators. There are a few that do all three. Elder law is a unique area of law that overlaps with estate planning and estate administration, and we'll spend one day at the end of the semester talking about some issues in elder law. All right, so estate planning broadly, we're going to talk about wills. Again, remember that a will only is going to control probate property. It is prepared by a testator. There are various requirements, and you'll hear me say this quite often, that a will speaks at death. A trust could be embedded into the terms of a will, known as a testamentary trust, or could be a separate document created during lifetime. The person creating it is the settlor. If it is an inter vivos trust, it could be either revocable or irrevocable. And there are requirements, but those requirements are much different than a will. A power of attorney and advance medical directive are agency relationships. The power of attorney deals with financial powers. The advance medical directive deals with medical powers. The power of attorney is an agency relationship where the principal designates the agent to act on behalf of the principal for financial matters. A power of attorney terminates at death, and the agent owes the principal the duty of loyalty and care. 2010, we in Maryland enacted the POA Act. That has been also updated a few times, including during the 2023 legislative session. You have the most current and up-to-date statutory forms, which are part of the appendix. The most important case in the power of attorney arena is the King v. Bankard case, which basically holds, even after the POA Act, that a power of attorney is strictly construed, meaning if the power of attorney does not allow the principal to act with respect to certain things, primarily the gifting was what was at issue in King v. Bankard, then the agent has no authority to do so. The advanced medical directive, the most popular case is the Terry Schiavo case. That does two things. It names someone to be your agent to make medical decisions for you when you are unable to do so. And secondly, makes your wishes known regarding life sustaining procedures. So in King v. Bankert, think about who are the parties, what kind of power of attorney is involved, and what provision would have changed this case. Overview, because we really do not spend much more time on the POA and AMD. What are they? Who are the parties? Why do you need them? How does it survive disability? What does it mean to be a springing POA? All of these things are laid out for you in the materials. Make sure that you read it, and we will talk about it in class. Now, the second part of chapter 1 talks about inter vivos transfers. Something happens during lifetime so that it moves the asset from a probate asset being in the sole name to a non-probate asset. It either passes by contract, for example, life insurance and retirement accounts, and also the Totten Trust in the Green case, or automatically by joint tenants with the right of survivorship, or tenants by the entirety in Maryland, or by title. If there's a gift, there's a life estate, remainders, trusts, inter vivos trusts. Okay, so those are the three primary ways in which property passes outside of probate by contract automatically or by title. Example, life insurance, if you aren't familiar, is a contract between the insured owner and the insurance company in which, upon the insured's death, the insured has designated some beneficiary to be paid. Very similar to a life insurance policy is a retirement arrangement where you designate a beneficiary. Uniquely, taxes are likely due with retirement, with the exception of a Roth IRA. These assets have been accumulated during the holder's life without paying income tax, and therefore income taxes are going to be due by the beneficiary, the recipient. And there's a new law called the Secure Act, which allows various deferrals to occur up to about 10 years now. So you don't have to pay the income tax on the accumulated retirement of the decedent, and you can pay that out over as much as 10 years. All right, so let's take a look at the Totten Trust. That is a type of non-probate asset in which there is going to be a beneficiary designation. And that's what happened in Green. Maryland has adopted the multiple party account statute, which Totten trusts are included as part of that. In Green, there was an inter vivos agreement where the decedent established with the bank to pay out these 8 bank accounts with POD designations. It's not really a trust at all. They call it a Totten trust, but it's not really a trust at all. It's much more easily compared to with a payable on death kind of arrangement. All right, so think about the arguments. The spouse says, hey, this is nothing but a probate asset. Why? She wants it brought back into the estate. If it's probate, it passes in accordance with intestate succession. If it's non-probate, it passes directly to the children. And the children are ultimately successful in arguing that the Totten Trust is a non-probate asset. What about a joint bank account? Assets that pass by operation of law. Well, when you co-own property, it's either as tenants in common, joint tenants with the right of survivorship, or tenants by the entirety. Property held as tenants in common are, in fact, probate assets. Joint tenants with the right of survivorship and tenants by the entirety have a survivorship feature and automatically pass to the survivor. What's the difference between joint tenants with the right of survivorship and tenants by the entirety? You can only have property held as tenants by the entirety if you are married at the time that you acquire the property. You take a look at the problem. When I add someone's name as a joint tenant with the right of survivorship, that trumps the will, right? So it's going to pass to the daughter. The sons could argue that it's pulled back into the estate, but there is a rebuttable presumption when someone puts uh, a a party's name on the account that it will pass to the recipient. So you've got to be very careful with that. Thirdly, we want to think about retitling assets, and we look at the Gruen case with gifts. Think about who are the parties to a gift. Remember, the requirements from property are intent to make a present transfer, delivery, and acceptance. In this case, we have a gift of a remainder interest. And I know how much you all love property. To A for life, then to B. Then to B is the remainder that dad had transferred to son. Very interesting case, the evil stepmother with respect to the picture, but luckily, son was successful. So think about the federal estate tax ramifications. Dad had bought the painting. He said, "Here, son, happy birthday, but I want to keep possession." That's because that was a no-no because a transfer with a retained interest for federal estate tax purposes is part of the estate. So that was problematic for the lawyers, which is why they had father replace the letter. No gift tax return is also part of that advice that the lawyers had given. But the son is able to make the argument that this was not a gift of the painting, but this was a gift of the remainder interest in the painting. And that's what made the difference. That's how the son was, in fact, successful. All right. See you soon.